The community property problem from February of 1995 is another quintessential community property question. It is typical in just about every regard. But as we focus on it, we'll see that there are a couple of issues that are variations on our typical theme. And I think you'll see, particularly if you are learning community property by working through this seminar, you'll see some more details that you haven't seen before, and it will be well worth your attention. Take a look at the call of the question. On what theory or theories may 1. Flo assert rights against Mike because of his child support payments? Discuss. 2. Flo asserts rights in or to the $20,000 savings account. 3. Mike assert rights in or to the bonds. Discuss. 4. Flo assert rights against Mike as a result of the taking and sale of the diamonds. Discuss. And 5. Flo assert rights against Bud for acquiring out of his assets the diamonds. Discuss. Answer according to California law. Well, the fact that they are asking us about a bunch of different property according to California law is all we need to know that this is going to be, at its heart, a community property problem. We can intuit that Flo and Mike are a couple in the question and that Bud is a third party who has acquired some asset that might be a community asset. So we are sensitized to community property as we look through the fact pattern, and we also know that we are dealing with a 5-part short answer series rather than one elaborate essay. So let's go to the top, and in paragraph 1 of this fact pattern, we see what makes this a variation on the theme rather than something that is entirely run-of-the-mill. We've got an unmarried couple. Bud and Flo, as we indicate from the call of the question, are a couple who were not married, but who were living together, and what they do is they enter into a contract whereupon they intend, apparently, to opt in to the community property method of analyzing their joint or community assets. So we've got a meretricious relationship, a non-marital relationship. And the first question presented is, basically, can they opt in to the community property laws? And the answer is, yes, they certainly can. They've got the freedom to contract in despite the fact that they are not married. So, we see at the end of paragraph 1, Flo is injured and had to quit her job. In paragraph 2, we see the couple living off of the putative husband's wages as a bartender, from which he paid $500 a month to support his children from a prior marriage. That gives us the child support issue, and what we know from the black letter law, those of us who are acquainted with the black letter law, is that child support payments sort of trump community property laws. We will look to separate property to make these payments, but if none is available, community property absolutely is liable for those debts. In January 93, Mike inherited $20,000, which he put into a savings account in his name alone. We know that devises are separate property, but we also already know that this guy Mike has got a separate property obligation, and that's the child support. So the question is getting somewhat more complex and interconnected. Still, it's not that hard, and as we'll see, the analysis is fairly straightforward. In paragraph 3, we see Flo receiving $400,000 in settlement of her personal injury claims. These will be given to the injured partner in the relationship unless the interests of justice demand otherwise. Flo invests her half of the settlement in diamonds and the other half in bonds in her name alone. So Flo has taken title to all this money, and she has spent it on bonds and diamonds. In paragraph 4, we find out that Mike takes the diamonds and sells them to Bud for $100,000, and then Mike loses this money while gambling in Vegas. Flo was unaware of the sale and removal of the diamonds, and also unaware of the gambling losses. Once again, another glimpse into human nature as featured on a community property fact pattern. In paragraph 5, now Mike has left Flo and sued to enforce their agreement. Flo denies the validity of the agreement and has asserted appropriate counterclaims. Flo has cross-complained against Bud, seeking recovery of the diamonds. The bonds Flo bought are still worth $200,000, and Mike's savings account contains $20,000. During the time that Mike and Flo lived together, Mike paid $18,000 from his wages in child support. And then we get the call of the question again. So now I think you can see that it is possible to make community property pretty complicated. But notice that the real complexities here are really arising out of the law of remedies as opposed to the law of community property. Again, of course, these distinctions are somewhat arbitrary. This is all civil liability stuff, and so all of the different variables are interconnected. But take a look at the outline of issues that I present, and I think you'll see that it is possible to manage this complex fact pattern by imposing on it the same format we always use: source, actions, and a conclusion based on the presumptions. So up front, I have a separate little section about the agreement. This is going to contain the bulk of the information that usually is present in the boilerplate that I so decry. And the reason it will be useful here is because the nature of the relationship is different than that in the typical fact pattern. So I spent a little bit of time on it, as we will see together in a minute or two. Next, we focus on the child support payments. And we know the source of these payments was community funds, the money that he made during the time that he and Flo lived together under this agreement. There are actions that we must cover. First, the special law that covers child support payments, which I alluded to earlier and which I discuss at greater length below, and the 1993 inheritance. Before this inheritance, it doesn't seem apparent that Mike had any money to pay this child support, apart from his wages. But at the time that he receives this bequest, then he's got separate property funds with which to pay this separate property obligation. I reach a conclusion, a fairly predictable one from the analysis I've just outlined. We'll have a look at it again in a moment. Next, we consider the $20,000 savings account. The source is the separate property source. We consider some of the interlocking issues with regard to the actions and reach a conclusion. Similarly with the bonds, the source is the personal injury proceeds recovered by Flo. We consider those rules and the actions that are connected to them and reach a conclusion. Next, we consider the diamonds. Here, the source is the personal injury proceeds. The actions include the sale by Mike to Bud of these diamonds for half their value, and then Mike's action in losing all of this wealth, gambling. We reach a conclusion, again, not terribly unpredictable. Then we reach the last cause of action, Flo versus Bud, with regard to the diamonds, and as we'll see, even by traditional remedies standards, we do not have a BFP situation because Bud paid substantially below fair market value. So even though he may not be with actual notice of underlying problems, he's on constructive notice because he paid so little. Okay, that sets up our analysis, and the lesson to be derived is it's always a good idea to impose a structure on a question based on how we understand the subject to be tested. This is a complicated fact pattern, but we can make it a lot more simple and manageable by imposing order on it. So let's take a look at my answer, and you'll see up front I have 2 paragraphs before we actually get to the marital estate, or in this state, the estate of a couple opting into the community property system. You'll see in the first paragraph, I lead with the facts, I cite the Marvin case, and I go on in the second paragraph to enumerate the big picture of what the consequences will be, assuming that this couple is allowed to opt in to the community property system. And I indicate that Mike's departure date would be the date of separation for community property purposes. Next, we go into the child support issue, and as predicted in the outline, I spell it out pretty much according to the way the law dictates. I start off with the source, I focus on the specific facts. Then I move to the actions, and here I work in the special rules governing child support payments. It doesn't take me very long to get all of those details in, but you need to be patient enough to really do it. So I am very specific in focusing on the dates and indicating exactly when Mike became capable of paying off this separate obligation with his own separate funds. And I say in the conclusion, ultimately, from January of 93, when he got this inheritance, until the time that he left Flo, he will have to reimburse the community for that money spent. And Flo gets 50% of that total amount. Next, we consider the savings account. Here we've got a separate property source, the inheritance. Next, the actions indicate no commingling and no other actions that would change the separate property nature of that money. Yet, when we get to the conclusion, we need to indicate that, as we discussed above, some of this money may have to be used to reimburse the community for community funds that were spent on the child support. I don't spend a lot of time making that connection, but in my judgment, it is a vital connection to make. Next, we move on to the issues surrounding the bonds. The source is the personal injury proceeds recovered by Flo. Notice in the paragraph under source, I lead with the facts and I explain exactly how the law deals with PI winnings in a community property situation. They are deemed to be a community asset, but they are awarded to the injured spouse at dissolution unless the interests of justice would be served otherwise. So I focus on the actions. Flo buys the bonds in her name. That act, unilateral act by Flo, doesn't change the nature of the bonds as community property. But it is worth noting. So I conclude by awarding the bonds to Flo because Mike is able to support himself and she isn't, plus Mike has at least some small amount of separate property of his own. Next, we focus on the diamonds, and here we see that the source was, again, the personal injury proceeds. It's community property money. Mike sells the diamonds to Bud for half of their value without giving notice to Flo. It's true that community property law allows each spouse to exercise dominion and control over community assets. Still, a spouse is not allowed willfully to dissipate a community asset, and that's what's happened here. The sale to Bud, as I described, is a disguised gift to Bud of 50% of the value of the diamonds. And Mike is going to be liable to the community for that $100,000, of which Flo would be entitled to $50,000. Then, next, we have to deal with the fact that Mike is a bad gambler in addition to being a bad companion in romance. He loses the $100,000 gambling in Vegas. He gets to exercise dominion and control over this property, and Flo is not entitled to reimbursement for this. The gambling is legal. So the conclusion is Flo gets $50,000 from Mike as compensation for the shortfall in the sale. But she doesn't get compensated for the money that Mike lost in Vegas. It's too bad for her, and sometimes these harsh results are the correct answer on the bar exam. Next, we focus on Flo's rights against Bud regarding the diamonds. And here we focus on the BFP status. Still, it looks as if Bud and his actions are tainted by bad faith, and the fact that he paid well below value should put him on notice as to something being amiss. So, consequently, I turn Bud into a constructive trustee of the diamonds, and I require him to return those diamonds to Flo. And that wraps up a consideration of another racehorse question. Like many community property questions, the issues are pretty straightforward. They are served up on a plate, and you've got to be able to digest them quickly and give them back to the examiners in the Blue Book with plenty of value added.